Aggravated sexual intercourse with a child between 10 and 14 years is an offence under Section 66, capital C, subsection 2 of the Crimes Act here in New South Wales. The maximum penalty for the offence is 20 years imprisonment. It's what's called a strictly indictable offence, which means it must be decided in a higher court, such as the district court. It cannot be decided in the local court. To be guilty of the offence, the prosecution must prove three things beyond reasonable doubt. The first is that you had sexual intercourse with another person. The second is that the person was aged over 10 years and below 14 years. And the third is that there was a circumstance of aggravation. Now, in relation to the first element, that you had sexual intercourse, there is a video on this website about the definition of sexual intercourse. In relation to the second element, that the person was over 10 and below 14, the prosecution must prove knowledge of consent. That is, that you had knowledge of consent. So they must prove beyond reasonable doubt either that A, you knew the other person was under the age of consent, i.e. under 16, or B, you were reckless as to whether the other person was under 16, or C, that you had no reasonable grounds for believing that the other person was under 16 years of age. Now, this knowledge of consent is determined through all of the surrounding circumstances. For example, your previous dealings with the other person, the context in which the incident occurred, any specific inquiries that you made about their age, and their response to those inquiries, if there was any. The third thing that the prosecution must prove is at least one of 9 aggravating circumstances. The aggravating circumstances are 1, that you intentionally or recklessly inflicted actual bodily harm upon the child or someone else who was present. 2, that you threatened to inflict actual bodily harm on the child or someone else nearby. 3, there were 2 or more people present at the time of the offence, that is, you and at least one other person. 4, that the child was under your authority. For example, you are a parent, teacher, carer, or babysitter. 5, that the child has a serious cognitive impairment. 6, that the child has a serious physical disability. 7, that the child was deprived of their liberty before or after the offence. 8, that you took advantage of a child under the influence of drugs or alcohol. And 9, that you committed another serious offence at the time. For example, you broke and entered the house. If you are guilty of the offence, the sentencing statistics suggest that 86% of people were sent to prison. The average prison sentence was 6 years full term, that's the entire sentence, and a 3-year non-parole period. Now, the non-parole period is the time that you must spend in prison before applying to get out of prison. 9% of people got a suspended sentence, and that is a good behaviour bond, which, if breached, means that you are likely to be sent to prison.